Let's talk probate and real estate. As a real estate slash probate attorney, one of the most frequently asked questions that I get is, Rachel, how do I avoid probate? Probate seems to be something that a lot of people want to avoid because it is cumbersome, time consuming, and there's potential for litigation. So it is very important for individuals to understand that probate's not necessarily a bad thing, but if you want to avoid it altogether, there are techniques and things that you can do in order to avoid probate, especially when it comes to real estate property. In the state of Florida, we are a lien theory state. So, a lien theory state essentially says that you will get a property conveyed to you and the title will be given to you. So, you'll have the deed at the time you close at that closing table. But a mortgage will be recorded as a lien to that property. So, if you ever try to convey the property, sell it, or do anything else with it, that lien has to be taken care of. And typically that is what happens in the state of Florida. Now, the beauty of having a lien theory state is that you have access to your title. You don't have to wait till after you paid off a mortgage or satisfied the mortgage in some way to be able to get your title to convey it and do other things to it. So what you were able to do is you're able to change the deed, add on to the deed, or modify the deed at any point in time because you have access to that information and you have it available to you. Now, with that being said, here are 3 techniques that you can use to avoid probate in the state of Florida when it comes to real property. Number 1, taking title. When you take title to a property, that essentially says this is the owner. Now, there's different ways that you can take title to a property and different types of possession that you can have over a property. Typically, when you have a married couple, they will take the title and that property as entities by the entireties. And in the state of Florida, you're considered to be one undivided interest. You both have 100% interest. So that essentially means that if one of you passes away, the other person gets the interest of the property 100%. There's no need to go through probate. It is just a matter of law. The only thing you would have to do is record a death certificate on your spouse, and then you will assume 100% interest in the property. The other way to take interest is by joint tenants with rights of survivorship. And what that basically says is that we may not be related, we may not be married. It's typically business partners or even just partners that are not legally married, because in the state of Florida, we don't recognize common law marriages. So it will just say that me and this other person will take title, and then if one of us happens to pass away, the other person gets 100% interest and doesn't have to worry about going through probate. So that is the second way of actually taking title. Now, there are other things that can be done, and we'll cover that next. Few states in the United States recognize an enhanced life estate, also known as a ladybird deed. And a ladybird deed essentially gives you the right to do whatever you want with that property, but should you die in possession of that property, there is a remainderment interest that will go ahead and vest into whomever you name to be the new owners. So, for instance, you can have a life estate on a property saying, I live on this property for my whole life. But if at the moment I pass away, I still have any interest in this property, then I want it to go to these individuals. Now, it could be very specific. You can say, I wanted to go 50-50 to my children. I wanted to go to my business partner. I wanted to go to an entity. You can do whatever you want and convey whatever interest you want to the other individuals. But the beauty of it is that as long as you own the property, you can do whatever you want with it. You can mortgage it, you can lease it, you can do all types of things. You have a right to live in it, you have a right to possess it, and you have a right to act as if you own it. So there's no limitations on what you can do with that property. So you don't have to just live in it and then wait till you pass away. You would be able to live in it and mortgage it, do whatever you want on that property. But if you still own the property at the time of your passing, then the people that you name to be your remainder men will end up having the interest, and they simply will have to record a death certificate on your behalf with the county where the property is located, and it will automatically vest into those people. The third recommendation I make is to use a legal vehicle to be able to convey property. You can put your property in a trust. You can put your property in an LLC. You can put your property in a will. And these legal documents will indicate and show the general public how you want to manage this property. If you put it in a trust, a will, or a legal entity, then there are documents associated with each of those forms of legal vehicles to be able to convey those properties. So if you have a trust, in your trust you can say, well, I want to live in this property, but the moment I pass away, I want it to go to my heirs, or I want them to liquidate, or I want them to rent and split the rents. Whatever you choose to do with that property, you can do it in a will or in a trust or in a corporate structure. The corporate structure is really interesting because you can have documents that will allow and appoint a person to do certain things on behalf of the rest of your heirs. So these documents that you put in a will or in a trust or in a legal entity will govern how this property is then conveyed and distributed amongst your heirs. So this is a different vehicle in order to avoid probate. You would just have to name an appointed party to manage everything on your behalf. And the beauty of it is that you get to say and instruct as you want, and all your wishes will come true according to that document. So what's the takeaway? You can avoid probate in the state of Florida. You can avoid having to have your family and your heirs go through this cumbersome process called probate. But what you have to do and what you must do is plan ahead. So planning ahead is always going to be key. You can have an estate plan, you can have a will, you can have a trust, or you can even deed the property the way you want. And just remember, thinking ahead, planning ahead will always guarantee a successful outcome.